Good morning, everybody. I'd like to call to order the Delaware County Board of Elections Board meeting for November 16, 2022. And please rise and say the Pledge of Allegiance with me. Thank you. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, good morning. So we're going to start as per our agenda with the consideration of the agenda. But I am going to recommend that we adjust the agenda significantly, so I want to just talk about that. We're here today, we're called today really for the purpose of consideration of the recommendations on provisional ballots and consideration of objections to those recommendations. I understand that we have at least one objector who intends to present. Under those circumstances, we run essentially and mainly, Mr. Solicitor, please correct me if I get anything wrong. We will run the equivalent of a hearing. And we will hear argument, and we will have board discussion, and ultimately, we will need to vote on those objections. But I think for these purposes, that's a big focus and the reason we called the meeting. So it seems to me appropriate to table sections 5 through, not 10, but 5 through 8, which is really more equivalent to a traditional meeting, not a hearing setting, to our meeting on the 22nd of November. And that's when we would hear the Director of Elections report and other comments, and other public comments as well. I'd like to hear from my fellow board members if you're amenable to that suggestion that we adjust the agenda to only focus on items now 4, and then of course we can announce the next meeting date, which I just have, which is November 22nd, and then adjourn. So any thoughts?
Madam Chair, I'm in agreement with your recommendation. That's my understanding, the purpose of the meeting really today is for the consideration of the provisional ballots. At the next meeting next week, presumably we'll be ready to certify and take official action on all the things that we've discussed thus far.
Mr. Alberts?
I concur.
Thank you. All right, so then with that, Mr. Allen, we would amend the agenda to remove items 5 through 8. Item 5 through 8, we'll consider those comments different from hearing the recommendations on the objections. And then similarly, we have a voter registration meeting agenda. I know our voter registration team is very busy right now processing ballots and continuing to process provisional ballots, for example, that we will be discussing today. So I recommend that we table that meeting to the 22nd as well. Mr. McLean, do you have any concerns about that recommendation?
I do not, and I wouldn't expect that we would have any real business voter registration during this period of time.
Mr. Alberts?
I agree, and I'm sure they have a lot of work to do that we could let them get back to.
Do we need Mr. Solicitor, do we need a formal motion to amend?
I would think that just to be safe, let's do that.
Okay. So then I move to amend both the agenda of the Board of Elections meeting as well as the agenda of the Voter Registration Commission to remove the items we've previously discussed.
I'll second.
Any discussion further? No. All those in favor say aye.
Aye.
Aye. Thank you. That motion passes. All right. With that, we will start with the consideration of recommendations on provisional ballots.
Morning.
Good morning.
So we started our review of provisional ballots the Thursday, I think, after election. I'm getting all my days mixed up. The Thursday after election, we started around 10:30, 11, I believe. We had a lot of observers, which were all great. They reviewed each one. Each provisional gets print screens. It's where we investigate and ensure to see why they voted provisional. Were they in the right precinct? Were they eligible? Were they in the county or another county? And each of those get those print screens and our review sheets on the front, where the provisional came from. Once my staff checks those provisionals with those print screens, fills out the review sheet, we do a second check with me or Michelle at the table outside with the observers. They can go through each one, look at the print screens, and it's kind of like a double check where then we do our official count, what we think it should be, if they missed anything. We had a total from what the judge of elections had wrote on the front of the main envelope where provisionals go into at the end of the night, election night, or on election day, we estimated about 2,447. That number came out pretty good because after we got all of our review sheets done, we came up with a number of 2,458. That's more current now. We also believe that there's going to be 1,759 full counts, 113 partial counts. Now, some of those partial counts could go into full count if everything is in common, such as the senatorial districts, state house districts. If everything's in common, that ballot all would count. So that would go into a full count. And then our no counts, 474. We also, as we were reviewing them out in, at our table outside the voter registration office with the observers, we came with 112 that were challenged.
And Ms. Winterbottom, I just need to pause you right here because I did forget to say something. We are both, I think, being recorded, but additionally, because we are going to have an objection presented today, we are also, there's a stenographer, court reporter is on the line, and they are recording this hearing in case anybody would like to challenge it later. So as we get to that issue, I just wanted to stop you and just make sure I noted that for the record that everything we're saying is being recorded.
Also, Crystal, could you be sure to introduce yourself, give us your name and your position
yes,
with our organization?
As
that's
we
quite
get to
all right.
this. Now we're getting to the part that this less prospective and more
So I am
concrete.
Crystal Winterbottom, Chief Clerk of Voter Registration.
Okay. So we're talking now about 112.
112 that were challenged, correct. The challenge is in one group, so all of these 112 that were challenged were all mail-in ballots that were received at the Bureau of Elections office that were canceled for no secrecy or canceled because the voter didn't sign their outer envelope. These were all mail-in ballots that were received at the Bureau of Elections office and canceled, but that voter didn't come to the voter service center by election day or on election day. They went to the polls and voted a provisional.
Ms. Winterbottoms, before you proceed, 2 questions just so the record is clear. First, these were all ballots that were timely received by the Board of Elections, that is by 8 p.m. on election day?
Correct.
And second of all, did the universe of ballots involve any that were incorrectly dated or were missing a date as another type of defect? You mentioned not signed or naked ballots.
Correct, yes.
Thank you.
So were all of the ballots at issue subject when they were canceled to the cure notices that we asked the voter registration department to issue?
The voter registration office didn't send out those notices to the mail-in ballot voters. Is that what you were asking? I'm sorry.
That is, well, sorry, did someone in the Bureau to your?
The Bureau of Election had sent out notices, yes, that's correct, to cure their mail-in ballot, whether it was a secrecy or the date or they didn't sign it, to go to the voter service center and cure that mail-in ballot.
Okay. Mr. McLean, do you have any questions for Ms. Winterbottom?
Well, before we get to the challenges, I just had a couple general questions.
That's right. That's where I think we should start before we get to this specific objection. We may have additional questions after.
Yeah, just in general regarding the numbers. Thanks for those numbers. I was kind of actually surprised that the number of full counts versus the number of no counts. I would have anticipated this time that we would have had a lot of people who mailed in their ballots, but then there was a lot of publicity in the run-up to the election regarding damaged ballots, uncured ballots, that sort of thing, and that people just sort of belts and suspenders might have showed up on election day saying, I want to make sure my vote counts, so I want to cast a vote, and they would have been handed a provisional. So quite honestly, I would have, just my own logic, would have expected there be a higher number of no counts, because for people whose mail-in ballot was received and was okay, and they were just, what of the 1,759 full counts, Was there a certain category that most of those fell into?
Yes, so most of them that I know that I saw were a lot of ballots not received at the Bureau. So in the poll book, there's a section, the signature box, and there's a watermark that says that they must remit their mail-in ballot, surrender it, and sign, but they have to vote provisional. That's so when we check the provisional, we see, did they get that mail-in ballot back if they didn't surrender that mail-in ballot? A lot of these full counts were ones that never sent back their mail-in ballot to the Bureau, so the Bureau never received it. So, and at the polls, they have to vote provisional. So yes, they were most of those full counts.
Okay.
Yeah, I would just add to that, based on I'll speak to me, and Crystal can correct me if this is not correct. My personal observation is since general election 2020, this has been the pattern, is that a giant piece of the provisional ballots are people who signed up to vote by mail, then did not return the mail-in ballot, came into the polling place, didn't bring their mail-in ballot and return envelope, and so they are by necessity and rule, and kudos to our poll workers who are following our directions and our training on this, voting provisionally, and then, Crystal's team checks to make sure we did not get a vote by mail ballot back. Obviously, if they return their mail-in ballot or remit it at the polling place, we know they didn't separately vote it. But if they don't do that, there's a risk they might have, which is why we make them vote provisionally.
Yeah.
But even if they didn't do it intentionally, are there some batches of mail-in ballots that went out at the end because the voter asked for mail-in ballots at the very end of the deadline?
That I do not know how mail-in ballots are.
That's fair.
I think Jim, I'm not sure about that.
Fair enough.
Other than, any other recurring patterns? Were these, for instance, geographically, were they spread out all over the place, or?
No, they were all over. Some of these full counts that I noticed as we were going through our partial counts, that the partial count number that we're at 113 right now, that was larger yesterday. But that has went down because a lot, even though they went to the wrong precinct, or maybe it was in the same polling place and they went to the wrong table. They weren't in their poll book, so they voted provisional. But everything in their districts from that precinct to the other were in common. So that is a full ballot counted that we categorize that in. So some, not all, but some, that was another large grouping of provisionals in the full counts.
Okay. Thank you.
Yes.
Thank you. Mr. Albers? Okay. All right, Ms. Winterbottom, Mr. Solicitor, then I think the time is to hear the objections.
Correct.
Good morning. My name is Shelley Chauncey. I am the Assistant Solicitor of the Delaware County Democratic Party. It's my understanding that the vast majority of the watchers who were there observing on the counting of the provisional ballots were representatives of the Democratic Party. They are at our direction. We did initially lodge objections to a couple of issues that have since been withdrawn. And the only issue that remains is this issue of what I am defining as the voters' attempt to cure their ballots. Unfortunately, I'm not going to have any witnesses today. I attempted to call several of the voters who have not received notice of this hearing. It was my understanding that according to Section 1209 of the Election Code, they should have received notice. But I think because of the short distance of time between the finalization of the count and the scheduling of this hearing, they had not received notice, and the first time they were hearing about it was when I called them.
I just want to pause there. It's my understanding voters will receive notice. If we could, Mr. Allen, when the time that they will receive that notice for.
It's been the practice of the board to notify voters if we had them in the count category or the partial count category, and then if there was an objection to their being counted. In this instance, it's the exact opposite, where we've listed them as no count, so the only possible outcome, if the objections were to be sustained, would be to count their ballots.
That's correct. That's been the practice, and it's my understanding of the way we handle things this time as well.
Again, it's my position according to the statute. They should have been notified, but I'm prepared to proceed.
Thank you.
With the understanding that I may be talking about a couple of specific voters who were not able to come because work schedules. So in particular, I did speak to a couple of voters, which revealed to me that the notice to cure from the county or their efforts to cure in this matter was not consistent based on the notice from the County Board of Elections. For instance, one voter received a voicemail message on her phone, and unfortunately she deleted it, so I couldn't play it for you guys here today, that instructed her to come to media or to vote provisionally to correct her ballot. Another voter received a letter, and in fact his letter was attached to his provisional ballot, stating that he had to come to media to cure his ballot. He was an elderly citizen and could not get transportation to media, so his decision was to go to the polls to cast a provisional ballot to ensure that his ballot was counted. Finally, the last voter that I spoke to with specific different issue received an email from the automated system that is received, I guess, when your vote is either counted or not counted, and it's received from the Department of State. And in that email, and I do have a copy of that email. 1 second. He received 2 emails, and I believe I have 4 copies, so I apologize. I know I had 3 for the, however you want to hand them out. He received, his name is, the voter's name is Isaiah Dorsey. He received 2 emails from the automated Department of State system, one stating his mail-in ballot had been canceled. The second email was with specific instructions on how to proceed. And you will see in the second email in the specific instructions, it states, it does not give the exact county procedures, but states that he should go to the polls if his county does not have procedures to vote provisionally. Now, I will say at this point, and as of the time that I spoke to him yesterday, this voter had not received any notice to cure from the county. Those are the specific issues that I noticed with regards to the ballots that we've counted, that the notice to cure did not consistently get out to the voters. And I understand this is a first time that the county has offered that option, which I appreciate the option to cure. But I think the issue here is because the voters did not have the appropriate instructions, they did not understand what they were supposed to do. And now what I believe is most important to consider here is the voter's intent. Every one of these voters clearly had the intent to cast a ballot, regardless of the party. And I should say that even though I'm here as a representative of the Democratic Party, we were challenging voters across party, challenging the board's decision across party lines. We did not distinguish whether those voters were Republican or Democrat. So a couple of the other points that I want to point out is in October of 2020, the Pennsylvania Department of State issued guidance surrounding provisional voting. In that guidance, and before I pass this up to you, on page 2, so the second page here of the guidance, is the Department of State's specific guidance as to when a provisional ballot may be cast. It specifically delineates in the bulleted list that if a voter cast a provisional ballot, a mail-in ballot that was rejected by the county, then that is a reason and a justification to cast a provisional ballot. Additionally, in one of the initial lawsuits surrounding the mail-in ballot dating issues, that ultimately resulted in a couple of weeks ago with the county issuing the notice to cures and the ability to cure. In the initial lawsuit in 2020, there was a letter as an exhibit from Jonathan Marks, the Deputy Secretary of Elections and Commissions, that was sent out to all of the election directors in October of 2020, referencing this guidelines that I just passed up to you, where he again states that voters who have completed the absentee or mail-in ballots that are rejected by the counties may be issued a provisional ballot. And I'm passing that up for you. So
And does Mr. Marks cite is there a statutory reference for that?
he cites the guidance that I gave up to you previously, the October 21st, 2020 guidance.
So he cites his own opinion.
Well, I don't know if it was his opinion or the Director of the Elections Commission's opinion, but yes, it's the guidance that was issued twice to the Board of Elections.
And does the guidance cite any statutory authority for it?
I believe it may. I don't have a copy in front of me. I passed up all my copies to you guys. So on the second page where the bullets are,
I think there is, Ms. Chauncey, a statutory provision that is at issue here, right?
correct.
So should we?
And again, I don't have my
Whether
copy in front of me.
Whether or
so-
not Mr. Marks cited it or not, I think just to frame the issue out, there is a statutory provision that you're, I think, arguing should be interpreted one way in favor of counting the votes.
That's correct.
Okay, so if we could get to that, I do want to discuss that.
And the last piece in terms of guidance is if my suspicion is correct, again, I have not spoken to all 112 of these voters, but based on my limited conversations with the voters I did speak to, if my suspicion is correct, many may not have received a notice and cure from the county. And if their mail-in ballot was rejected and they either voluntarily went to the polls without seeking additional guidance, or if they went to the Department of State website, the Department of State website specifically states, and this is a printout of the provisional ballot section of the Department of State website, which was printed out yesterday at like 5 o'clock. It states again that if their mail-in ballot was rejected, that they could cast a provisional ballot. So in several different instances, voters were, if they did not receive the specific guidance from the county, their understanding or their attempt to cure this issue could have been seen as the appropriate mechanism would have been to cast a provisional ballot. Now, I will say that there are other counties since the most recent Supreme Court decision regarding the dates, other counties in the state and the Commonwealth are allowing provisional ballots as an attempt to cure. Delaware County did not follow that for whatever reason. That's irrelevant at this point, but other counties are allowing provisional ballots. And I think the discrepancy between those counties, the Department of State guidance, and what the county issued itself as a notice to cure created a lot of confusions for the voters. And I think by not counting these ballots, we are clearly going against the voters' intent to cast a ballot in this election. I do have one more. This is from the Philadelphia City Commissioners who are in charge of Philadelphia's elections, which also states that they are allowing provisional ballots as an attempt to cure.
Just before, it's a fine point, but I just want to make sure the record's clear. The county board, and this is at my direction, did not refuse to issue provisional ballots to these voters. The only question is whether to count them. So
Right.
When you use the phrase allowing provisional ballots, I assume really what you're talking about
Allowing
is
the count.
allowing the counting
That's
of those
correct.
ballots. Because all of these voters, which is consistent with federal law,
Right.
were indeed provided provisional ballots.
That's
The only question
correct.
is whether to count those ballots now.
That's correct. At no point, from my understanding, at no point were voters prohibited from having a provisional ballot. Because as Ms. Winterbottom discussed, when these voters went to the poll, it would have stated in the poll book either to remit the ballot, surrender their ballot, or the mail-in ballot was received and to cast a provisional. And that's in fact exactly what these voters did here. Now, I did want to say that the one other thing, the argument that your solicitor and I had a conversation about briefly was that it was his opinion that on the provisional ballots envelope, the voter signs an affidavit that states that they did not cast another ballot in this election. Now, I will argue that this is a fine distinction here, and it's an important distinction, because while the voter did attempt to cast a mail-in ballot, that mail-in ballot was rejected. Therefore, it's our position that the voter did not effectively cast another ballot. And their attempt at casting their provisional ballot is their attempt to actually cast their ballot. And until that ballot is scanned and counted, they have not actually cast a ballot. So I would argue that this is not in opposition to the affidavit that they signed, because they were clearly told that their ballot didn't count. So in terms of the voters' position, they had not actually counted a ballot for this election.
Thank you, Ms. Chauncey. I just want to make sure I want to frame out the issue in the way I'm thinking about it and just see if we're all on the same page. And so we have 112 voters who were told in whatever way or somehow came to the understanding that their ballot was canceled.
Correct.
If they'd gone on the SURE system, my understanding is it says canceled. They, in principle, our goal was through our CURE program to give them notice that their ballot was not going to be accepted and that they should take attempts to cure if they chose to do that.
Correct.
And I understand that in our guidance that we issued and and I think it was at the request of the Department of State, we said, go to media.
That's correct.
Okay. And there's other guidance that came out that says go to media, and I'm looking at the ballot itself, and at the bottom it says you don't vote provisionally. It says if you receive, okay.
Is that a copy of the provisional ballot?
No, this is the actual official ballot. It says,
Okay.
in part, it says, if you receive an absentee or mail-in ballot and return your voted ballot by the deadline, you may not vote at your polling place on Election Day. If you are unable to return your voted absentee or mail-in ballot by the deadline, you may vote a provisional ballot at your polling place on Election Day unless you surrender your absentee or mail. Well, so it's a little confusing. Going back, this is confusing, and Mr. Allen may have some views on how to say that. But certainly in our guidance, and this is their guidance. Mr. Allen, which guidance where was this issued? This one right here?
So I want to mention first off.
Wait, I don't want, I just want to finish my train of thought. I know it's a little bit, I'm trying to process all the evidence, but I just want to make sure I have it. Is that we directed voters to go to media. And this is this notice, when did this go out and who did it go to, Mr. Allen?
Well, both the instructions that went out with the vote-by-mail ballots and then the vote-by-mail ballots themselves had language that was also dictated by the Department of State.
Okay.
So, and they cited statute. I don't have it available. However, they required us to print on the ballots that if the ballot is received, the voter may not go to the precinct polling place. And in consultation with our legal counsel, we determined that the safest route for the voters was to require them in our notice and cure process to come to the voter service center and obtain a replacement ballot, because we did not want them to vote provisionally and then have someone of a different viewpoint than yours object to their ballot and then have it in jeopardy, either here or in court. So we were following Department of State guidance, which clearly, as you're pointing out, they have other guidance that they've posted on the internet or elsewhere that is not consistent with the guidance that they ordered us to place on every ballot and to place in our instructions to the vote-by-mail voters.
Okay, and that's
So-
what we have here, is the vote-by-mail instructions, and then I assume this is the instructions that I was referring to that are on the ballot that they would have received. Now, you present strong evidence that the Department of State also gave contradictory
Well,
guidance.
I would say, what I would say is not that you guys are giving contradictory evidence. I don't think that's the issue here at all. I think the issue is that maybe your guidance was not as broad as the Department of State allowed. Now, I will say with regards to the mail-in ballot instructions and the thing at the bottom here, that is not in contemplation that their ballot will be rejected.
I'm going to get to that. No,
Yeah.
don't worry. I am going to get to that. So we're all in agreement that there's guidance from us, from the Department of State, guidance that we used from the Department of State, and it tells the voter different things in different places. I think that I'm confident that there may have been some confusion on this issue given to some voters, right? That they may have received contradictory advice. And I think I've been very clear since I joined this board that I am all in favor of franchising the voter if we can do it under law. So to me, all of that, the evidence that these are voters who 112 of them tried to vote twice. I mean, in principle, right? They're
Well,
trying to get their vote cast. I don't mean
trying-
illegally. I
okay,
mean,
yeah.
they tried to vote and by mail, and then they said that it was canceled, and so they tried again to vote provisionally. So these are the type of voters that are really working hard to get their vote cast, right, and
Correct.
counted. But for me, it comes down to what is the law, and does the law prohibit the count or not? And it's interesting in indicia of what the law, or the confusion that the law may have created, that at least some counties, you're saying, have interpreted as allowing provisional ballots to be cast in these circumstances. So I think you hit at the very end of your argument what I see as the two most salient issues, is whether their vote was cast, right? And so that they could truly sign the affidavit correctly, and that is, I didn't cast a vote, whether the notion that they had been informed that their vote was canceled meant that they hadn't cast a vote. What does cast mean? And I think the second part is the statute. And I think I have the right statutory provision, but Manley, I just want to check with you, is Section 1204A45 little 2 says, a provisional ballot shall not be counted if, Section F says, the elector's absentee ballot or mail-in ballot is timely received by the County Board of Elections. Now, our Ms. Winterbottom used the word received. We received these ballots. So now we need to talk about both what cast means and what received means. And what I hear you arguing, and just want to make sure I have it clear, is they didn't really cast a vote, and you could make the adjacent argument that the county didn't really receive a vote if it was bounced at the door, right?
That's correct.
Their concept of casting means they expect something will be counted, has the potential to be counted. They've been told it's not going to be counted. The concept of received, it's been welcomed. It hasn't been kicked out before it got in.
And I should note that their ballots are still sealed in secrecy envelopes in there, right? Their mail-in ballots, I'm sure, are still sealed in their envelopes. I think some of them were canceled because they lacked a secrecy envelope. But it's my understanding that no one has opened those sealed envelopes and looked at it. So has the county received their ballot? Because nobody's opened it, nobody's scanned it, nobody's cast the ballot. And these voters are being told, your ballot's not going to be counted. And because not only with the confusion with the language back and forth, but the confusion as to how they were notified of an attempt to cure that ballot. Some voters received a phone call that may have had incorrect information. Some voters received an email from the Department of State that says you can go to the ballot and cast your vote, which is what they did. Some voters may have received a letter which had the instructions but were unable to come to media to be able to correct that. And I think by not allowing these votes to count under these very confusing and difficult situations is disenfranchising all 112 of these voters. And I will say, I suspect, I'm highly confident that there are more of these ballots that are in the no count list. I was only present on Friday and some of Saturday. I was not present on Thursday when the count began, and I do not believe our observers started lodging any objections on Friday to these. So I believe there are no count ballots with these issues that were not challenged on the day of. So there are, my suspicion, more than 112.
Well, and again, the voters' intent and their efforts and all of that is really just, important in one sense. But to me, right now, it comes down to, can they sign an affidavit truthfully? And I don't think there's no sign of fraud or nefariousness, right? There's no, I think, allegation that necessarily happened. Can they sign an affidavit truthfully that they hadn't cast a ballot? Because if they were untruthful in their affidavit, we would need to reject it. And can we distinguish the idea of receipt from that's in the provision, the statutory provision, from when we've bounced it, when we've told them it's gone, it's canceled, not at the door. And I mean, frankly, I looked up the word receive in Merriam-Webster this morning just to make sure, I wasn't overtly being cute. And it really is to welcome, to enter in, to accept in. So if those two things are fair interpretation, then your argument, with me at least, wins. And if they're not, then I think that if others say, and I think you can say, and I think it has been said, at least in an unpublished decision in Allegheny County, is my understanding, it has been said that that those ballots shouldn't be counted because of that language of received. They didn't, I don't think they focused on the affidavit, I think they focused on the receipt. But in there wasn't, I didn't see, and Mr. Solicitor, again, I just want to check with you, I didn't see indicia that the court was considering this notion of canceling by the county itself.
The court did not, the analysis of the majority opinion in that case did not deal with that question. So it didn't sort of specifically raise it as a counter argument and then reject it. It just didn't deal with it. It quoted the statute and said received is, did you get them or not? And didn't deal with, well, what happens if you get them and say no thanks?
Right, okay.
And I will agree with you 100% that if the county received their mail-in ballot and it was counted, they cannot vote provisionally, right? That's clearly an illegal vote. So I think that's the important distinction here is the ballot was canceled. And so the Allegheny County decision, nor the statute contemplates the cancellation of the ballot.
And I'm inclined to believe that when a voter casts a ballot, they have the expectation, there's expectation that it's going to be counted. Whether it is ultimately or not is a different story. Maybe they misfill it out or whatever, but they've cast it. These voters have been told it wasn't cast. Same with receipt. They've been told basically it's been bounced. So that's where I'm going, but I expect that there may be a lot of questions. And so, Mr. McLean, would you like to ask any questions of Ms. Chauncey?
Well, I'll go back and maybe Mr. Manley, my copy of the code, I don't have the consolidated, but what is the section that applies here? What is the section regarding canceled ballots and what you should do?
The section is cited in the communication that I sent around yesterday evening, and I'll pull it up.
Yeah, and I think you had like 30, 50 or something like that, and I suspect that's the consolidated, because
Right, 3050.
That's the affidavit. Is that what you're referring to, section 2 here? I have it here if you'd like to. I can read it if it would help, the underlined language.
yeah. So I have the code itself, so it's only,
Yeah,
it goes up to like section 1800.
Thank you, if you'd like to make a copy. Is that what you? Oh.
Yeah, that's all right.
I can read it. I think this is the section, it says, Section 3050 of the Election Code, which addresses, among other things, the process for voting provisionally states, and again, skipping to, so it's A42. Is that the section you read the bold part?
I would think so, yeah.
Prior to voting the provisional ballot, the elector shall be required to sign an affidavit stating the following. I do solemnly swear or affirm that my name is blank, that my date of birth is blank, and at the time that I registered, I reside at blank in the municipality of blank County of the Commonwealth of Pennsylvania, and that this is the only ballot that I cast in this election, and then they need to sign it. Is that?
Yeah, that's one of them, and then I think I'm looking at the first one, and I apologize, I just saw this, I know.
No,
Mr.
this all
Park
came
said
up
it to us
late.
last
It all
night,
came-
I just
it's all
saw it
late
this
breaking.
morning. Maybe it's our notice provision that he's there, but, well, let me say this, rather than, I certainly agree in terms of, we want everybody to be franchised to the extent possible, but there are rules that are set in order to make it fair for everyone. If somebody got a notice from Delaware County that says, hey, the only way to fix or cure your ballot if it's been damaged or you haven't signed it or you didn't provide the secrecy envelope is you have to come to the voter center and media. If somebody got that advice, but not advice that, it's possible to just cast a provisional ballot on election day, which some people may view as easier to do, that creates an inequity, in that somebody doesn't get the chance to cast a provisional ballot. And I think that's where we were, and I think that's probably what the law provides for. Here, we ended up with the Department of State, and I'll premise this by saying I think our board and the members that I have served with, have gone to extraordinary lengths to try to make sure that the playing field is even in Delaware County and that, we're just calling balls and strikes, the same for everybody. But I did, I look and see, what the Department of State sends out, for instance, to Mr. Dorsey, which is the only, email that we have. Mr. Dorsey did get an email from the county that said this is what you should do. Then he gets an additional email from the state, where the state now is trying to help Mr. Dorsey cure it. And I think, again, the Department of State, my opinion, I'm sure it's not shared by everybody, took various actions during this elections that I view as political. And, they really tried to stretch the bounds of what the law is or what their advice ought to be in order to try to benefit, some candidates. But nonetheless, I think, from my opinion in this situation, Mr. Dorsey did get an email, from a state agency telling him that, he could go and cast a provisional ballot. I don't think that there's any sort of fraud. None of these 112 that we're talking about are duplicate votes. None have the chance that they were counted there. So because of the conflicting advice, that voters got, this election from the Department of State versus from the procedures that the county adopted. And we were one of, I'm not sure that the majority of counties in Pennsylvania voted to allow people to cure ballots. We did that unanimously here. I think we gave people a chance. At some point, you're no longer the innocent victim, where you've been told, here's the instructions, here's how to do it. You don't do it correctly, you're told how to fix it, you don't fix it correctly. At some point, you disenfranchise yourself. Correct. We're not doing that to you. So here I would support the idea of counting the provisional ballots, these 112, because some of these people may have gotten conflicting evidence or conflicting direction from the Department of State. That being said, I think we need to examine this as a precedent going forward. I think that, that's why I keep referring to the statute. I think the statute itself, quite honestly, talks about that they should go, that it can be cured here, but not by provisional ballot. I admire your argument regarding what received means. But I do think here the ballots have been received. For instance, they have been. And Mr. Allen can correct me if I'm wrong. We receive them, we stamp them in, we send them through the Blue Crest machine, or we hand wand them in. I mean, we necessarily have to do that in order for them to get an email kicked out to them. So, I think we have received it. But like I said, nonetheless, for this, for these circumstances, my thought would be to vote to allow these 112 ballots to be counted, because some of these people may have gotten what possibly is incorrect information from the Department of State. But nonetheless, I don't blame the voters for that. I blame the Department of State that's trying to, in my opinion, take interpretations that will push people or push an election one way or the other.
Well, we come to it from different places.
Yes.
Because I do think in this case, I'm pushing the law's language, but I appreciate that the Department of State clearly did, at least from this email, indicate that they could vote provisionally. Mr. Alberts, though, you have not been heard from.
Just before Mr. Alberts speaks, I just for the record want to get the citation in the exact statutory language that we were looking for. It again is 25 PS 3050, and in addition to the provision that the Madam Chair read in regarding the declaration that, or the affidavit that the voter who wants to vote provisionally must sign about having only cast, or had not cast another ballot, there's another section of that or another subsection of that very same section of the code, 25 PS 3050 A4, but this is 5 Romanet 2. And that section, if we start at 5 Romanet 1, it says, except as provided in subclause Romanet 2, if it is determined that the individual was registered and entitled to vote at the election district where the ballot was cast, the County Board of Elections shall compare the signature on the provisional ballot envelope with the signature on the elector's registration form, and if the signatures are determined to be genuine, shall count the ballot if the County Board of Elections confirms that the individual did not cast any other ballot, including an absentee ballot, in the election. Then we go to Romanet 2, which is the carve-out. If a provisional ballot shall not be counted if, and then skipping down to F, it says, the elector's absentee ballot or mail-in ballot is timely received by the County Board of Elections.
That's the latter part I read at the beginning, but I did not read the earlier part.
Right.
That's
And then it
helpful.
comes to the question of, is received the same
I
if
don't know,
it's
don't try
rejected?
to, you have Mr. McBlain with you for a different reason.
Hey,
and it's
I'm
your
not,
email.
I'm finished.
And I would also add that I don't believe, my understanding at least, is that the email that the one voter received from the Department of State, I believe that's a standard form email that's generated upon the cancellation of a ballot.
It is.
So it's probably fair, at least as I understand circumstances, for the board to assume that anyone who tried to vote by mail ballot, whether absentee or mail-in, and had that ballot canceled, received an email with that same wording. I don't think that's a custom email.
And, you know, before Mr. Alberts, you speak, I think we should read that in because there isn't formal exhibits entered. It's just, it's an email from the Department of State on Sunday, November 6, 2022 at 11:58 a.m. And subject is notice from PA Department of State regarding your mail ballot status. Please review. And it's to Isaiah Dorsey. It says, "Dear voter, your ballot has been received by your county election office. However, our records show that your ballot has been marked canceled," that's in bold, "because there was an error on your balloting materials. Voters should contact their county elections office to discuss their options to fix/cure issues with their mail ballot. You can find a list of county contacts and there's a website. If the county will not allow a voter to fix the error, then the voter should go to their polling place on election day and ask for a provisional ballot. If you believe you have received this email in error, please disregard it. Sincerely, Lee M. Chapman, Acting Secretary of the Commonwealth." Mr. Alberts.
So, one of the distinctions I hold on this board is I'm the only person up here who's not an attorney. And so, as I
You're going
listen,
to say it's a proud distinction?
well, it's a noble one in its own way. I do love the law and I do love wordplay. I have a history degree, so words are a thing that I've always liked. I bet a lot of people in this room thought they had a very clear understanding of what the word received meant before this discussion. And I think this is indicative of the sort of things that an ordinary voter, maybe one who isn't a lawyer or it doesn't have a college degree or even a high school diploma, but is a fully entitled, qualified, registered elector attempting to cast their vote in good faith, can often run against a form that looks pretty clear to one person, but can be very confusing to another. And to Mr. McLean's point, there was a lot of confusing information coming from the Department of State that we were grappling with. We're like, well, this court says this, but this court says that, but the Department of State tells us to do this, and the statute says that. Just imagine if you got two conflicting emails, belts and suspenders. You get yourself to the polling place, and you ask the judge of election, what do I do? Well, the judge of election does this twice a year. We give them as much training as we can, but they're ordinary residents and citizens just like the rest of the folks in this room. And they do their best, and they do a great job. And one of the things that we give them as a tool is the Election Day Guide, which included language from the Department of State, which read, provisional ballot will count if there was an error in logging the mail-in ballot. So you've shown up at your polling place. You ask the judge of election, what do I do? I witnessed lots of judges remember their training and say, oh, go to media, cure the ballot. And people got in their car and they did it. But how many other judges said, oh, it says right here, provisional ballot will count if there was an error in logging the mail-in ballot. It doesn't say whose error, right? So there was an error. This mail-in ballot was not logged. So there's a whole lot of good faith that gets to a point where a perfectly qualified and registered elector could be disenfranchised, you know, because they don't know how to read something correctly, or they didn't properly, you know, grok what was in a form. And I don't think that's someone's failure to understand is not a compelling reason, in my view, to disenfranchise them, particularly when the remedy here, I mean, there's no dispute these voters are qualified and registered. We can be sure they won't be voting twice. As you say, we have them in the bins, segregated. We know where their mail-in ballot is. We know where their properly executed provisional ballot is. You know, the judge of elections, they brought their ballot to a judge of elections in the polling place, and the judge of elections voided it. We wouldn't be having this discussion because it's very clearly, you know, there's that ability there. The material effect in this case is the same. We're voting it here rather than they're voting it at the polling place, and the ultimate effect is that a qualified registered elector will cast their vote. So I think it's a long way of saying I think I agree with the general direction that I hear you guys saying.
For a third reason.
for maybe different reasons.
I did
yeah.
wanna add
And I
one
also want to say,
point.
furthermore, I think that there's my concern here about this conflicting information from the Department of State is that I don't want to ever be in a situation where anyone associated with this organization is providing misleading information to a voter that is disenfranchising them, because that's voter suppression. And I don't think anyone here or at the polling places was doing that intentionally. I don't think, but I think if that's the effect, well then it's the same as if they had filled out their ballot in green ink rather than black or blue ink. We would still count it.
Well,
did
is there an
wanna-
opportunity, Mr. Allen, for that feedback to be given to the Department of State? Because I do think that it's problematic when we look at all the different pieces that were presented, and I don't think it's intentional.
Well, in honesty, and most importantly, in defense of our staff, we were getting all kinds of rule changes in the middle of the game.
Right.
And Ms. Chauncey and I had a couple of discussions where we're really trying to be umpires, and I used the same metaphor that Mr. McBlain did, except not balls and strikes, but more precisely fair and foul. You know, here's the foul line, and we want to be able to call it consistently. And so we went into this election for the first time, the Department of State, in reviewing our vote by mail and absentee ballots, the samples that we provided them back in September, was very emphatic in writing back to us, you need to include this notice at the bottom of each ballot saying that if they return it, they're done. Then in the middle of the game, the Pennsylvania Supreme Court comes out with a decision saying, you know what, notice and cure. We presented to the board on October 25. We begin a very labor-intensive effort to go back through and identify naked ballots, unsealed ballots, instead of just unsigned and undated. Then, further down the line, after that, the Supreme Court issues another ruling that creates out of whole cloth, not in my opinion, just in my understanding of the law, the concept of improper dated. So it used to be a real clear foul line. It was either dated or it wasn't dated. And then, on top of issuing this edict of improper dated, they gave no guidance on what that meant. So we came up with what we thought what was a reasonable explanation of improper dated. Anything after Election Day, anything before the first day that we opened the Voter Service Center. Turns out we were more conservative than the Supreme Court, which then came out with guidance only the Saturday before Election Day. So we had to stop what we were doing and go through 49,000 envelopes through an intensive effort, in addition to the notice and cure process. And we tried to be very consistent with the guidance that we received from the Department of State, with the guidance that we received from our own solicitor, through the notice and cure process, and then through the voter registration department's review of all these provisional ballots. Only then, it's brought to our attention that, well, the Department of State also had these web pages where they referenced this. Again, we've heard the law today. It clearly doesn't really say that, but we appreciated the arguments that you brought to us, but we wanted to, Crystal and her team wanted to rule by the rules that they knew were in place before Election Day, and did so in good faith. And I think that's an important thing for the voters to know, that we do want to enfranchise everyone that we can, but we also want to follow the rules.
Yeah, and just to be clear, the Crystal and her team were following the solicitor's guidance on this. So
Yeah,
it's-
they're
it's
wonderful
the-
and amazing and have done nothing.
But I
This is
directed them
exactly
to
how
do
it should be presented. They received guidance from our solicitor, they followed it, someone objected to it, made arguments that persuaded the board. It's our job to supervise the election. There's nothing about the team other than to say you guys are awesome and do amazingly hard work. And now I think we're going to ask you to do even additional hard work. And I am going to ask if we when we move to do this, that we include in the motion that we batch it in case anyone were to want to challenge, that the votes be counted in a batch so that they could be removed if there was a challenge that was successful.
I did want to add one thing, because I want to thank Crystal and her team. She worked with us some long hours the last couple of days through multiple watchers. Her team has done a fantastic job. I think you guys have done the best that you can do under the circumstances and the situations you were given. Our challenge is not directed to any of the board's decisions in the past or even your attempt to cure. Our challenge was specific. This is a gap that we believe needs to be rectified. And I think as a team, everybody can work together moving forward to resolve this issue so that voters are not disenfranchised. And I commend the staff and the Board of Elections for doing a fantastic job. And I appreciate all the work that you've done under these challenging circumstances. Oh, and one other thing. In case it was not clear, these provisional ballots, if there was another justification for not counting the provisional ballots, we did not challenge them. So if there was another reason why they could be rejected, we did not challenge them. We only challenged the ballots where this was the only issue with those ballots.
And so, I mean, if we have a motion to sustain the objection, I understand, Ms. Winterbaum, you would only process those under those circumstances, that the only reason they were not counted was this issue.
Madam Chair, I would also ask that the board please consider in the motion accepting the non-contested items, including the 1,759 full counts, the 113 partial counts, barring any situation that Crystal described where we determine that all of the districts are in common and those can move to full count. And lastly, the 474 no counts.
Note that's consistent with how the board has proceeded in my experience here over the last couple of years, is to adopt the recommendation of Crystal and her team at voter registration with respect to non-contested.
Okay. That makes it a lot easier because I'm not sure that I have all the numbers written correctly on my piece of paper.
Thank you for allowing me to.
Thank you, Ms. Chauncey.
Now, those numbers could change. They are just us going through the box. I mean, I don't think drastically, but that's just us hand counting boxes. All these provisionals are coming in.
So we don't need to use numbers, right? We can say, so the first motion would be to, to accept all the decisions of the voter registration board on uncontested ballots, is that?
Correct. Yeah. On uncontested or unchallenged ballots, you would have a motion to adopt the recommendation of the voter registration department on that, and then.
Well, let's do that one.
Yeah, and then separately, we would have a separate motion for the other.
We'll craft that in. Okay. I guess I'll make the motion, okay, to accept the voter registration's recommendations on uncontested and unchallenged ballots. Do we have a second?
I'll second.
Any discussion further? Okay, all those in favor say aye.
Aye.
None opposed, that motion passes. Okay, now let's get to the properly framed next one, including the batching.
So I think that for this one, there's been a challenge to a universe of ballots that's sealed in a container here in the hearing that if it's based on the discussion, it appears that there would be the board would want to make a motion to uphold the challenge. And I would recommend that you further indicate in the motion what voter registration should do with respect to, and the board under Mr. Allen's, or the board staff under Mr. Allen's direction should do with respect to the ballots where you're upholding the challenge. Okay. And noting that the record establishes that the only basis for the no count recommendation with respect to this universe of ballots is this issue of the ballot having been timely received by the board or timely delivered to the board, putting aside whether received or cast is, how we define those things, but timely delivered to the board and then rejected for some defect.
Could so I heard Ms. Chauncey say something earlier, and I don't know if I misunderstood, but I just wanted to kind of clear it for the record.
Absolutely.
That in the poll book, it said to remit and sign, but that was referring to most of the full counts that we had, that the person never returned their mail-in ballot and was never received at the Bureau. So that's where it would say that in the poll book, where they would sign and remit or surrender. I wanted to get the correct what it said in the poll book. When the Bureau receives a mail-in the poll book, there would be a section where it says mail-in ballot cast not eligible. So those are those voters that wouldn't have that box to remit or surrender. I don't know if I misunderstood, so I just wanted to.
Ms. Winterbottom, it's worth mentioning, this language comes to us from the Department of State, does it not?
From the shore system, yes.
I had a separate question, Madam Chair. For the 112 that were challenged, have they been discerned about whether they should be all full counts, or do we have to go through them to see whether or not they should be partial counts?
The only notation, I think it could be a partial count or a full count, but the only reason it was rejected was because the Bureau received a mail-in ballot, nothing else. Everything else was filled out, everything else was complete.
So those 112 aren't all, perhaps aren't all full counts?
Some could be partials.
Yeah, you have to, okay.
Sounds like you want to craft this motion.
Well,
Because it does require a little nuance.
yeah, I mean, I will make a motion to sustain the objection to the 112 challenged ballots, and that we direct the voter registration and Bureau of Elections to count those 112 provisional ballots as may be either properly full counts or partial counts upon their discernment.
And can I add to that, to batch them, so that, will you add to your motion the separate them, keep them in a separate batch so that they
To
can?
sequester them and
Yes.
count them separately? Yes. I would amend the motion to they be sequestered and counted separately.
I think that's responsible.
Second that motion? All those in favor say aye.
Aye.
None opposed, that motion passes. I don't believe we have any other challenges. Do we have any other, we're not going into a full meeting, so any other issues on this particular topic of provisional ballots for discussion?
Not from the solicitor.
No, Madam Chair.
Any of my fellow board members?
I don't have any further questions at this time.
Okay. Then thank you. Then with that, we are adjourned. And then, just to be clear, sorry, the next meeting date is November 22nd. All right, thank you all.